My name is Sherry. I'm from the Pleasanton Library, and I just want to give it away to Jonathan. And thank you all so much for coming.
Thank you, Sherry. Thank you everybody for joining us this evening. And so we kind of want to touch on some topics that I think that are very important for residents, whether you're a tenant, whether you're a landlord, to kind of know some rules out there. There has been many changes. I think the Pleasanton Library System hosted a similar workshop that we presented last month. And so we're going to be touching on some of these topics again, just to kind of give you a refresher, because we're seeing that on the horizon, there's going to be things that are going to be changing in the future. So I want to make sure that the participants are aware of what these changes might be and how can that affect you in the future. Just a little bit of overview about ECHO. We are a fair housing agency, and so we do provide fair housing services to Alameda, Contra Costa, and Monterey counties. And we provide tenant landlord conflict resolution when issues arise between tenants and landlords. If you ever feel that you are being discriminated, please give us a call. We do have fair housing counselors that are tasked to investigate forms of discrimination. So even if you're not sure, feel free to give us a call. That's what we're here for. We're here to investigate for you and make that assessment for you. And our office number is on the screen. So the topics that we're going to be discussing this evening are, we're going to talk about the countywide eviction moratorium, the state policy AB 2179. We are going to touch base on the Tenant Protections Act of 2019. That's also known as AB 1482. And then we're going to talk about some rent increase information. It's something that our agency has been seeing quite often now. And so we also want to talk about security deposits. So just a disclaimer, the information that we're going to be providing today is not intended to be legal advice. We always let participants know that the information we're providing you today is for general information and educational purpose. And then, if you need legal assistance, reach out to us. We can refer you to some of the partners in your community that can provide you some legal advice or even legal representation. So just kind of a history about how all of the policies that are in place came about. And so it first began with Governor Newsom issuing a state of emergency related to COVID back in early March of 2020. And then in mid-March of 2020, Governor Newsom then allowed local governments to basically impose their own eviction moratorium or eviction protection. And so, as a result of that, the County Board of Supervisors enacted that temporary moratorium on evictions in Alameda County. And so, this is basically the timeline that has occurred. And then since then, Governor Newsom has approved certain state bills to provide extra protections. They not necessarily provided, extra protections for those in Alameda County, but as we go through the presentation, you're going to find that the county moratorium is actually one of the more restrictive moratoriums in the state. And so even without state protections, a lot of residents still find relief from the rules that are written in the county moratorium. So just as a reminder, the Alameda County eviction moratorium does impose a ban on all evictions against tenants who are not able to pay their rent. But there are exceptions. So there are situations where landlords may terminate or evict a tenant, and we're going to be going through what those exceptions are. This is not a rent or mortgage strike, so rent will still be owed. I've worked with quite a few, actually a lot of landlords, and they feel that maybe their tenant is not going to pay any of this anymore, but that's not entirely true. This basically becomes consumer debt, and the owner will still need to go to court and try to basically get a judgment against the tenant to recuperate that back owed rent. This moratorium does apply to units in unincorporated and incorporated areas of the county, and there is a set of procedures. And so we're going to be discussing that this evening as well. So, the duration of the moratorium, and this is something that we get asked a lot. So in terms of how the county wrote the moratorium, they essentially said that the county will provide these protections and will exist 60 days after Governor Newsom decides to end the state of emergency. And so, Governor Newsom has not signaled that California is no longer in the state of emergency. And unfortunately, I do not have a, crystal ball that can tell me the future. So sometimes I do get landlords asking me, well, when do you think? And my response is usually, well, to be honest, I don't know, because I don't think anyone ever anticipated that we would be in the pandemic 2 years out. And so, once Governor Newsom decides that we're no longer in the state of emergency, residents in the county will have 60 days extra for these protections, which means that after the 60 days, landlords can resume normal eviction proceedings. And then I made a note on the screen that, as I mentioned, there were some state policies that Governor Newsom also enacted. And so those have kind of ended already, but the policies that he ended did not signal that the pandemic ended. And so we're still in the pandemic. And so, I have more information we can discuss later on the slides, but I just want to emphasize residents in the county still have protection with the county moratorium. And so owners still need to follow those rules. So under the county moratorium, it essentially says that a landlord is not allowed to evict or retaliate against a tenant. And so the notice of termination should not be served between March 24, 2020, which was when the Board of Supervisors enacted this moratorium, and 60 days after the expiration of the local health emergency. And so generally, if a landlord is serving a tenant that termination, the tenant can then raise that as a defense in their unlawful detainer lawsuit. And so there's various legal aid agencies in the county that can assist you with answering this. You can go to the courthouse and there's a self-help that you can get in order to fill out your documentation to respond to an unlawful detainer. In addition, the county moratorium also states that no late fees, fines, or interests may be imposed for rent that became due during this period. And so this is something that I've had conversations with property managers. And so I always tell managers, pull up the ordinance. Let's read it together so we can both be on the same page. And then sometimes it's, they maybe didn't read that section. And so that's why it's really important that if you're an owner, you're a property manager, that you have a responsibility to know what these policies are in its entirety. And so no late fees, no fines or interests. I will say that there are 3 situations that the landlords can terminate a tenancy. And I have seen them during the pandemic. I'm not going to say that evictions are not possible, but they are possible if they meet one of these 3 situations. So the exceptions to the moratorium. So the first exception is, if the landlord is removing the unit from the rental market. This is also known as the Ellis Act. What this means is that the owner is deciding to not be in the rental business no more. They have every right to say, hey, tenant, I don't want to be a landlord no more. I don't want to be in this market anymore. So I'm withdrawing my home from the rental market. And that is allowed. And as a matter of fact, this is kind of what we've been seeing, since the pandemic, because landlords are selling their property because they can actually make a large profit. And so, they have a right to remove the unit from the rental market. The second exemption is if the landlord has a government order that basically states that the tenants need to vacate because maybe the unit is not safe or they received a judgment against them for some other reason. And so having that government order means that the tenant will need to vacate. And then the third reason is for health and safety. And so the county did make this a little bit vague. They did not specify, what health and safety is, but basically they stated that, the continued occupancy by the tenant will pose a threat to health and safety. And so I've made a note on the screen that, you can't use this reasoning if a tenant has COVID-19 or has been exposed. And then as another note, whichever reason, one of these 3 reasons that the landlord is using, the landlord has the burden of proof that the exception applies. And so if the tenant forces the landlord to go to court, then, through the unlawful detainer or the eviction, then the owner should be prepared that, they have a valid reason for one of these 3. So evictions based on non-payment of rent. This is really the biggest protection that the county has provided to residents who have been impacted by COVID. And so what the county has said is that a landlord may not evict for non-payment of rent or late fees resulting from pandemic-related qualifying reasons. And so under the county rules, a qualifying loss includes substantial loss of income or substantial out-of-pocket medical expenses related to COVID, or childcare needs which are caused by COVID. And again, they can be used as a defense against any eviction lawsuit, based on the fact that the tenant's not able to pay rent. And I can't emphasize this enough. No late fees, fines, or interest may be imposed. I see this on a weekly basis, and we do have to provide some education to private owners or even property managers, etc. So the procedures, and this is really, really important because I've had some long conversations with tenants who believe that, they're inherently protected, but they don't want to follow the rules. And so, there is a set of rules that they have to follow just as landlords. So number one is that the landlord must provide a copy of the ordinance and a notice of termination that contains, county specific language. And we're going to be talking about that. And then, residential units located within a city that also has a local moratoria. For example, the city of San Leandro, they have a city-specific moratorium. And so that moratorium, a copy of that ordinance needs to also be included. But what the tenants need to actually be doing is they should be notifying their landlords that they will not be able to pay rent on or before the day rent is due. And so this is kind of one conversation that I've had consistently, that tenants need to be making that good effort in communicating with their landlords, the property manager, or whoever you're dealing with, is because, we can't expect owners, property managers to read your mind. And so, I can't emphasize this much, but really the more important thing is that tenants are going to be required to provide that proof. If you want these protections, you will need the proof. And so I've worked with tenants who will say, well, this is an invasion of my privacy. And I said, and I usually say, I understand your concerns, but do you want the protections or not? If you don't want the protections, then that's fine. You'll most likely go through the eviction process, but if you want the protections, you have to give something up. And, I'm not saying put your social security number, put very personal information, but you do have to provide some documentation, and we'll talk about what that documentation looks like. So this was the required language that I was talking about, that the county is requiring owners, property managers to include in that notice of termination. You can, if you need a copy of the ordinance, we can provide you a copy of the ordinance as well. So documenting a qualifying loss. And so, as I mentioned, tenants, qualifying loss must be documented. So, you can't just self-attest, or you can't just say, I'm affected by COVID, but you don't want to provide any proof. The thing here is that, the tenant's not required to provide proof, at the time that they're notifying the landlord that they cannot pay rent. But a tenant must provide the proof within 45 days of the request by their landlord. And so you'll eventually have to provide it, whether you provide it now or you provide it later, you will need to be providing it. Must provide the documentation only if affected tenant is seeking protection from eviction for non-payment. So recall that I mentioned, there's two sets of protections under the county moratorium. The first one is if you cannot pay rent. The second one is normal types of evictions. So, any other type of allowable eviction. And I'm actually going to go back to the screen where I'm going to show you again the 3 allowable evictions that can occur. So these 3 on the screen are the 3 allowable evictions. So if the owner is trying to evict you with one of these 3, then there's really no proof that, whether you're COVID impacted or not, meaning whether you try to pay rent or not able to pay rent. If the owner's claiming number 1, that's a different kind of protection than the protection of non-payment of rent or not being able to pay the rent. So documentation proving that a tenant has a qualifying loss. So the easiest one that I have found is a letter from your employer that basically states, that COVID was a reason for the reduced hours or the termination or the reduction in pay. As a matter of fact, at the height of the pandemic, this was probably, employers were giving this out really, really easy. but maybe you don't, maybe you work at a restaurant, or, some other type of establishment where, you don't get these kinds of letters. You can always provide them a copy of your employment benefits. Um, I always suggest that you just provide them the first page that says that, you are going to be receiving unemployment benefits. Um, for those that have had a reduction in pay, an employee pay stub would be proof. Even bank statements, showing that the amount of money being deposited from work is substantially less. Any proof that you've had any out-of-pocket medical expenses caused by COVID, and then proof showing that the closure of a school or childcare, because of the pandemic. Again, tenants will be required to provide this information if the landlord requests it, and you do have to provide it within 45 days. So repayment of owed rent. So tenants are still obligated to pay their rent, and they will have to pay back owed rent as well. But tenants and landlords may agree to a repayment plan for unpaid back rent. And I always recommend tenants to try to set up a payment plan when, things start looking a little bit better for their financial situation, because, I've worked with landlords where their tenants owe $72,000, and that's a lot of money for anybody. And so payment plan is probably the best way to go. But what landlords should not do is basically change a lease as a condition of a repayment plan. And so, you shouldn't create a lease that establishes a payment plan, and that's the reason why you've created the lease. And then tenants have 12 months from the date the rent became due to repay what they owe. Thereafter, it's recognized as consumer debt. And so, landlords will need to basically go to court and submit this as consumer debt. And then we do recommend that landlords work with third-party rental assistance agencies to basically assist tenants with back owed rent. There was a time where the county had a large rental assistance program providing, up to 12 months of back owed rent for tenants that were affected by COVID. Unfortunately, that program, has no funds anymore, but we were always encouraged landlords to work with these third-party rental assistance program agencies because it's a win-win situation. In one sense, the owner gets payment for all that back owed rent, and in another sense, the tenant finds some relief, and especially when you're looking at $30,000, $40,000, $50,000. So one of the big questions we've received in the past is a tenant required to use their unemployment benefits towards rent? And the short answer is no, because unemployment benefits is basically kind of a reduction in pay. You're not getting 100% of what your pay was. And so, it is considered a loss of income. But we still recommend to tenants that they still try to make some payment towards rent if possible. So it might not fully cover 100% of your original pay, but the way I frame it is, tenants should also consider that at one end of the spectrum, landlords have been severely impacted. Many landlords have relied on your rent to pay their mortgage, to pay their property taxes, their insurance. And so they've also been impacted. And there's been a misconception that, if you own a home in the Bay, that somehow you are a millionaire. And that's not true. And so, I think when you frame it in that perspective, I think tenants become more empathetic of the owner situation. So we highly recommend that even if it's $100 or $200 a month, that's going towards back owed rent that you'll eventually have to pay. And so not too long ago, the state had passed Assembly Bill 2179. And basically what this Assembly Bill says is that state law, it is a state law that continues to prohibit a landlord from evicting a tenant for non-payment of rent if the tenant has applied for the COVID emergency rental assistance on or before March 31st of this year. And so what this really means is that the state is signaling that if you've applied for rental assistance, and your application's in process, or it's being queued, then, the owner can't evict you because you haven't paid rent. And then unfortunately, this extension would really only run through the end of June. And so, that's something to consider. But, someone had asked me, how does this protection relate to protections in the county? And so the truth is that it's not really adding an extra protection. And like I mentioned, the county moratorium is extremely robust. It's strict. And so, this particular one, I think, was meant for areas where there is no local moratoria in place. And so I will say that the county moratorium is more protective than the state policy. Doesn't mean that you can't get more protection. I mean, more protection is better than less, but just know that by default, your best option is to rely on the county moratorium rules. And so we're going to take any questions that anyone has regarding some of the information that I've provided so far. And you can submit your questions in the Q&A.
So Jonathan, there's a question, but it's about AB 1482. I notified the person that we will go over rent increases further on in the presentation.
Right. Yes. So we'll be talking about rent increase information at the end, because that's kind of been a topic that we've been seeing quite often in our office. So it sounds like there's no other questions. Actually, what would be the next steps if a tenant does not provide the required documentation to the landlord within the 45 days? Yes, so your next step is you begin the eviction process. And so something that I haven't discussed is that while the county has provided this protection, ultimately it is the court that decides whether or not a case is going to be heard. And so, this has been a very long discussion we've had with other housing agencies regarding this issue. But the truth is that the court has basically decided what cases they will take on regarding evictions. And so if after the 45 days, the tenant has decided that, they still don't want to provide the documentation, my next step is probably going to be to go to the courthouse, ask them, are you processing evictions? What types of evictions are you able to process? And then asking them, we have somebody who, is not abiding by the rules set forth in the county. Will you process this type of eviction? And so it's really up to the court to decide what that case and how that case is going to be heard. So, I know that it's not a clear-cut answer, or the answer that most people would like, but the truth is that the county court system does operate separately from, how the moratorium functions. We do have a question regarding rent increase, so I'm going to leave it in the Q&A box because towards the end of the presentation, we are going to be discussing rent increases. And then, so someone's asking, we have another question about, a tenant never being behind on rent payments, and then they get a 60-day notice to move out of the house without telling me the reasons, and now it's been really hard to find a place. So the answer is, as I mentioned, they have to include a reason. And so, give me a call tomorrow. We'll provide you the contact information, but if they didn't provide a reason, then it's not valid. And so one of the requirements that the county is saying is that the owners do have to provide a reason, and it has to be a reason under the county rules. And so this is something that myself and our staff view consistently when we receive these terminations, is we're looking for a reason, because if there's no reason, the first thing I'm going to do is pick up the phone, call the owner, call the property manager, provide them some education, let them know like, hey, this is what the county is saying. Have you reviewed the county ordinance? And if you have, then, just be aware that, it's not valid. And so the tenant's not required to move until you follow the real procedures. And yes, renting in the Bay is expensive. Even buying a house is expensive. And so this is why it's important to ensure that tenants understand their rights, because when you empower the community to know their rights, then they make better informed decisions, and then they're able to ask critical questions about what's being presented to them. Yes, we'll make available the slides to you at the end of the presentation. We will also have our phone number, and you can give us a call. And then, can the Ellis Act be used to sell the home? As long as you put on there that you're selling the home and that you're removing the unit from the rental market, you can. One of the things that have come up is that selling the home doesn't mean you're really removing the unit from the rental market. I saw a case not too long ago where an owner sold the home to their daughter, and they used selling the home as a reason to get them out, so then the daughter can rent the house at a higher price. And legal aid stepped in, basically told them like that's not going to fly, and so they had to rethink their plan. So my suggestion is always use the language that the county provides you. Don't create other language. Don't write other things. Just write what the county is telling you to write. And as long as it's validated, meaning, if you're going to say you're going to sell the home, but you don't sell the home, and the tenant wants to come back and sue you, then be prepared for that, because you didn't sell the home like you said you were. So that's why it's really important. And I'm a huge advocate about this, is what you write on these notices should be intentional and in good dealings. I'm sure you would not like your tenant to, be behaving in this manner as well. So just keep that in mind. I'm seeing a few questions in, so I see a few questions in the chat box about residents that have multiple lease violations, such as smoking, noise, unauthorized occupants. Are you able to evict? The answer is no. Those are not allowable reasons. The county did not say that the breach of contract is an allowable reason. Now, if the breach of contract is a health and safety issue, then you can use it. But again, the property manager, the owner, will need to make sure that they have proof to substantiate that. And so it's the county didn't make clear guidelines about that. But I think in their senses, they've left it to folks to determine, does this situation warrant a health and safety issue? And then if leases are up, Can they still be evicted? No. When leases are up, they go month to month. People have stated before, well, leases are non-renewal. Yeah, they might not be non-renewable, but they do go month to month. And so the county did not include that once a lease is up, the tenant should move out. So hopefully that makes sense. Again, please submit your questions in the Q&A. Just to make sure that I'm able to view them. I don't want to miss any questions if you submit them in the chat box. So we're going to go ahead and continue because there are some questions regarding rent increase that we've been receiving. And so I want to make sure we have some time to answer some of those questions. So I'm going to switch gears and talk about AB 1482. This is known as the Tenant Protection Act of 2019. And essentially, this law, this state law, addresses two things. The first one is just cause evictions. And then just cause evictions just means that in order for a landlord to terminate, the landlord must provide a valid reason. And we'll talk about what those reasons are. And then the second thing that this law did is that it said that certain units will have maximum rent increases every year. And so we'll talk about what those units are. And if you live in one of those units, just be aware that, a 20% rent increase may not be valid. And so there are maximum amounts that they can go up to. And then for just cause evictions, it would not apply for properties that already have existing local ordinances for terminating a tenancy. And so what I mean by this is that if you go pull up Union City already has a just cause ordinance. And so when I deal with tenants in Union City, I essentially only look at Union City rules. I don't even bother looking at AB 1482 because that city's ordinance was written before AB 1482. So just like anything, there are exempt units. So what I've listed on the screen are units where if you live in these types of units, then we would not apply AB 1482. So this would not be subject to AB 1482. And so the first type of unit is a single family residence that's not owned by a corporation, real estate investment trust, or LLC, in which one member is a corporation. Duplexes are only exempt if one of the units is occupied by the owner. Now I want to make this clear. It needs to be occupied by the owner, not by the owner's son, not by the owner's cousin who just moved from Guatemala, not by the owner's pet. It has to be occupied by the owner. I saw this quite often, and I have to tell owners, it's based on ownership, not by inheritance. And so it needs to be occupied by the owner. If both units in the duplex are being rented out, then we would apply AB 1482 rules. The third exempt unit is regulated or restricted units. So these are deed restricted units. They're going to include low-income tax credit properties and project-based housing. Most people will know if they live in low-income tax credit properties or project-based housing. Now, something that I want to make a distinction is Section 8 may or may not be exempt. And that's why it's important that when I speak with tenants, I ask them, well, what type of unit do you live in? Are you Section 8? If you are Section 8, are you living in a duplex, a single family residence? Are you living in an apartment complex where everybody's Section 8 or partially Section 8? And so this helps guide me in determining, okay, do you have these protections or do you not? And then the fourth exempt type of unit is housing built within the last 15 years. There is a property that I work with out in Union City where I believe they have 2 years left out of the 15-year mark. And so I don't apply these rules to them. Accessory dwelling units such as in-laws are exempt, unfortunately. Mobile homes and dorms are also exempt. So there's two types of terminations that are allowed under the state policy. And the first one is called at-fault terminations. So it's the first box. I do apologize. It should say on the top header, at-fault terminations. I think the system didn't translate that correctly. And so at-fault terminations just means that the owner is terminating the tenant because of the tenant's behavior. So the tenant has done something that has caused them to get terminated. And if that is the case, the tenant is not entitled to relocation benefits. The second category is that we call no fault terminations, and that's the second box on the right. And no fault terminations is when the owner is trying to terminate, but it has nothing to do with the tenant. The tenant has not done anything that has triggered the landlord to terminate them. And in that instance, the landlord does have to pay the tenant relocation benefits equal to 1 month of rent. And this needs to be, aside from the secure deposit. So you cannot pay them back their secure deposit and say that's the relocation benefits. Their secure deposit has a whole different set of rules that we're going to be discussing this evening. But just know that this has to be separate from the secure deposit. And as a reminder, a notice of termination must have an allowable reason to be valid. So you need to put a reason on there. And again, when I speak to, prior to the pandemic, this is something that I would always ask tenants, send me a copy, let's review it together and let's see what the reason is. And many times they didn't have a reason. And so I would pick up the phone, call the owner and say, hey, this is not valid. This is why it's not valid. You should reissue the tenant again. So on my screen, what you will see is 8 allowable reasons that fall under at-fault terminations. And again, I want to emphasize something. This is the state policy AB 1482. But remember, the county moratorium is still in place. So you still need to follow the county moratorium until the pandemic is over. Once the pandemic is over, you can actually use any of these 8 reasons listed on here. And then there's 3 other reasons on the next slide. But for now, I'm providing you this information because, what if the county decides that, the county moratorium ends at the end of this month? And so I want to make sure you're well equipped with some of this knowledge so you can be prepared of the things that you should expect and the things that you should be looking at. And so these 8 allowable reasons are criminal activities. So if the tenants are engaging in some criminal activity, again, you need to validate this. You need to make sure you have a police report. I spoke once to a property manager and they're like, oh yeah, the tenant's engaging in criminal activity. And I said, so you're a police officer? Are you law enforcement? Like, how did you make that determination? Like, did you go look at a civil code? What was it? And they said, no, well, I feel that it's a criminal activity. And I said, okay, let's backtrack a little bit. We don't follow what I feel. We follow the facts. And so what you feel may or may not be relevant. And so I put this out there because I see this all the time. I talk to managers and they say, the tenant is a bad tenant. And I said, look, doesn't matter if the tenant's a bad tenant, you have to follow the rules. And you cannot be saying and putting things that are not true, because if the tenant fights you on it, you better come in with your proof. And now you're spending money from a company that you work for, just creating these lies. And so please make sure that, obviously if someone went and murdered somebody, that's an automatic criminal activity, but framing it that way helps folks understand that this needs to be a validated criminal activity. The breach of rental contract, I think someone mentioned in the slides about, or the Q&A about, breach of contract. And yes, you can use breach of rental contract. It just needs to be on the contract. I've seen people come up with things that are not even in the contract. And I tell them, okay, so where's the breach of contract? And then they say, well, I feel that it should be, as like, but it's not on there. So, instead of saying I feel, next time you rewrite your contract, make sure you include that on there. So you got to make sure it's on your contract. You can't just create things. And unfortunately, I see this quite often. Failure to pay rent, again, you cannot use that reason during the pandemic, especially in the county. Committing a nuisance, and I think someone mentioned in the chat about unauthorized noise or excessive noise, that can be a nuisance. A tenant rejects a written lease extension. Maybe they've approached their 12-month lease and the owner wants to renew the lease, but the tenant says, no, I don't want to. Then that's grounds for the owner to actually evict them. Illegally subletting. I've seen this often. Sometimes we get calls where the master tenant wants to evict the subtenant. And then we do a little bit digging and we come to find out that the master tenant should have not been subletting to begin with. And so that just becomes a bigger issue to address at that point, because now the master tenant runs the risk of actually being evicted themselves. So, please read your contracts, your lease agreements, whatever you sign. Don't just sign it and forget to read the last 2 pages, because they might have sneaked in something that you might not agree with later on. Forfeit of an employee use unit. This is something that we call the manager's unit, where maybe they are a manager of a property. And so they are essentially been terminated or they quit their job. And so because of that, they have to let go of that type of unit. And then the last allowable reason under the first category of terminations is failure to allow landlord access to the unit. Maybe the landlord needs to go inside the unit to make repairs. But again, the landlord needs to provide that 24-hour notice to enter. You can't just enter unless it's an emergency. Then you don't have to provide the 24-hour notice. I see that we do have quite a few questions, and I'll answer those questions at the end of this slide, because I want to make sure we talk about the second category of terminations. And so the second category is the no fault terminations. Again, these are 4 reasons where it has nothing to do with the tenant, It has nothing to do with the tenant. It's just that the landlord, this is all strictly about the landlord. So the landlord wants to remove the unit from the rental market. Again, this is an allowable reason under the county moratorium, so you can do that. The landlord will move into the unit, their children, their parents, stepchildren. Now, I don't want to get a call and I'm being told that your 12th cousin removed that just flew in from Texas is going to move in. 12th cousin remove is not an immediate family member. I always tell landlords, say less, but provide context. Don't give everybody your life story. Yeah, so I don't want to hear, your cousin Susanna from Texas, she's, you haven't seen her since 25 years and she's really not your cousin. Then turns out that, she's a family friend. Unfortunately, family friends don't count under this category. The third reason is the unit is unfit for habitation. And so, maybe there's a structural issue. Maybe there was a thunderstorm and the roof caved in. And so the unit is unfit for the tenant to live in. And then finally, the unit will be substantially renovated. So with this fourth reason, I always try to emphasize that owners need to have a valid permit through the county, through the city, because if you're substantially renovating it, then you need to make sure you have the proper permits. You cannot just say, I'm going to go paint the walls. As a matter of fact, under AB 1482, it specifically states that the tenants would need to be moved out of the unit for 22 days in order to qualify for this fourth reason. And so I've had discussions with owners and they've said, it is substantially renovated and all I gotta, they don't want to show me the permit. And I'm like, okay, that's fine. I just have to contact the county or the city. I look and they're like, he's never applied for a permit. So to me, it's not hard to investigate. And I tell landlords, look, I'm here to try to help you as well. But lying or hiding things isn't going to help either of us. And if I'm having to go dig stuff up and I come to find out that you were lying, of course I'm going to let the tenant know that you're lying. And so just know if you're going to use this, make sure you have your permit. And then as I mentioned, tenants are entitled to relocation benefits equal to 1 month's rent if the owner, property manager, is using one of these four reasons. So it looks like we have some questions in the chat box. And so I'm going to skip the first one because that's regarding rent increases. And then we will go ahead and move down, and I'll save the questions here for those that I'm going to save for later. So if the lease moves to month after renewal, can the rent be increased multiple times in the next 12 months? Yes, the rent can be increased multiple times throughout the month. But here's an exception. We need to determine what type of unit, because we're going to be talking about in the next 2 slides about rent increases. And so if you go month to month and you live in an apartment complex, then that unit is still subject to maximum rent increases. And so that's something to just keep in mind. It looks like it is an apartment complex. So as long as they don't go above the maximum amount, you should be perfectly fine. If in doubt, reach out to me. Reach out to Tanya. She's the housing counselor out in Livermore and Pleasanton. And we can try to figure out, what's going on. But in short, if you're month to month, they can still increase the rent. But depending on the type of unit, which I will be discussing, is going to depend on, do you have a limit or not? The second question is, in the case of a fire to the home, if there is a termination, is the tenant to be provided the 1 month of rent? Absolutely, because that is no fault to the tenant. The unit is uninhabitable for the tenant, and so the owner should be providing that relocation benefits. As a matter of fact, if there was a fire, the owner should absolutely be using their insurance. You would not believe the amount of stinginess I've seen from some owners who will say, well, I'm not really using my insurance to cover this. And, I tell the landlord, well, that doesn't matter. You still got to pay the tenant that money, if you're having them move out at that case. Whether you submit that or not, that's up to you. But just make sure that, if the unit is not habitable and it was not caused by the tenant. Another question is, I had a Section 8 voucher in the year of 2019 and had to get pregnant. And got pregnant during the COVID-19. And the first time mommy, I didn't have time to use my voucher. Is it possible to get a renewal in any county or relocate? So what you're describing is what we call porting in with Section 8. And the answer is, it's going to depend. In order for you to port in or out, you need to be an active Section 8 voucher holder. And so you probably will need to go back and reapply for Section 8 because they didn't hold your spot. They didn't hold your voucher. And so you've probably lost your voucher automatically, which means you would need to restart the process again with regards to receiving Section 8 again. But yes, once you receive it, you can port out. You can go and use that voucher. There'll be a process in order for you to let's say, HACA, which is the Housing Authority in Alameda, to talk to the housing authority in Kern County about you porting out into Kern County. So it is possible. This would be my second attendance to will someone from the housing management or host be sending a renter's contract? No, we don't send renter's contract, because renter's contracts are specific to every unit. And every owner, every property management company creates their own contracts. So providing you a contract isn't going to really do anything, because I have seen one-page contracts. I have seen 25-page contracts. So unfortunately, we don't provide contracts. If you are month to month, what is the maximum amount that they can increase the rent? I will be actually answering that one in the next slide. The next question is, say you have a resident that has some sort of expected mental illness confirmed by law enforcement. Resident has family attempting to do wellness checks with law enforcement. There has been no sign of the resident or communication. At what point now can we assume that they may be considered a skip? So I'm not sure what you mean by a skip. I'm guessing, that they've abandoned the unit. There is a process for suspected abandonment. Generally, you post a notice on their door indicating that you suspect that it is abandoning of the unit. You have to wait some time period, and then you can always issue a 24-hour notice and go inside the home or the unit and check and see if there are things that are in there that belong to the tenant. So that's one strategy. If you want to talk offline, we can talk offline. There's a little bit of a nuance to that as well. And we can do that. But I will say this: if the tenant is paying the rent, they don't have to live there. They're paying the rent. Their obligation is to pay the rent. For example, if you buy a car and you don't use the car because you have to work from home, does your bank come knocking on your door and say, don't make a payment? Absolutely not. You still have to make a payment on your vehicle. Do a wellness check if it looks like someone's living there. And if the rent is being paid, then I wouldn't say that the tenants abandon it. They have no obligation to inform anybody that they're leaving the unit because they want to leave the unit, especially if they're still paying the rent. But I think it would be a little bit of a different story if, they haven't paid rent, there really hasn't been signs of habitation in there. Then I probably would begin the process of saying that the unit may be abandoned. The next question is, my contract expiring next month. My landlord said as soon as my lease expires, now am I responsible to have renter's insurance? Absolutely. Absolutely. If your lease says renter's insurance, you better have renter's insurance. I'm a huge advocate about renter's insurance because, if there's damage and, you're required to pay for it, that's what your renter's insurance is there for. And so, I think it's a benefit. A company that I've seen is Lemonade. I believe it's called Pink Lemonade. They offer renter's insurance. They offer pets insurance. You can go with them. I think they sell rates as low as $10. But yes, if when they renew your lease, they say, a condition of renewal of lease is renter's insurance, absolutely. I did restart the process and had received an email from approval in the East Bay from HACA. What are the next steps for a guaranteed housing opportunity? So we're not HACA. So we're not Section 8. I'm not, I don't associate myself with a public housing authority. So that would be a question that you would need to ask HACA about regarding what would be the next steps, because, you know, the agency I'm associated with, we do not, we don't find housing. We don't do dealings with attempting to find housing, especially if you're Section 8. So your question is more geared towards, you know, HACA themselves about what the next steps would be for you. So I'm going to go ahead and move along. You know, we have some extra slides, but I think moving along to talking about rent increase, because it looks like we have a few folks who have questions regarding that. So under AB 1482, the state has stated, the state policy basically says that there is a rent increase maximum. And so that rent increase maximum is going to be 10% or 5% plus the CPI. So CPI is called Consumer Price Index, and we will use whichever one is less. And in this case, because the CPI is 5 and 5 plus 5 is 10 and the maximum is 10, then in this particular instance, currently right now, the maximum rent increase is 10%. And then again, the maximum will only apply to covered units under AB 1482. So if you live in a single family residence, you're not covered. That means they can increase the rent 35%. If you live in an in-law unit, they can increase the rent 20% because in-law units are not covered. And so this is why it's important that, you know, when we have a conversation, I always ask, well, what type of unit do you live in? And then sometimes I can verify with the county assessor's website to kind of have a good idea of what that property is, because, you know, sometimes maybe the tenant doesn't know what exactly that property is. And so my goal is to try to investigate that for you. And then I will say that the maximum rent increase does change every 2 months. And so, you know, at the height of the pandemic, the CPI was 1.6. And so the maximum rent increase at that time was 6.6%. Right now it's 5%. And so it's, you know, I mean, 5% is the CPI, and so the maximum is 10%. So I do regularly check every other month just to see that there's an update. As of right now, the most recently published CPI is from April, I'm sorry. And so April shows a 5%, and so it will be 10% maximum. Before we move on, I do want to answer some questions that are in the chat regarding rent increases. So someone signed a lease last year. On the lease, it states that the rent will increase 20% once the lease expires, which will expire next month. Can I dispute that since the increase is 20%? I had no knowledge of these laws and I leased that last year. So my question is what kind of property do you live in? Because if you live in a single family residence, then it is allowable because single family residences are exempt from this maximum rent increase. However, if you live in an apartment unit, a duplex, something like that, then give us a call. We'll talk to you about the next steps. We'll even call management or the owners and let them know that this maximum increase is way above the allowable maximum increase that the state provides. And so, you know, that's something that I would definitely want to follow up with you offline, because I do have some other specific questions I would like to ask to get a better idea, you know, with what you signed, but also, you know, once you go month to month, and, you know, I've seen this happen where it is an allowable rent increase. Once you go month to month, you know, if you don't want to pay this rent increase because you don't have this protection, you're more than willing to move out. But in terms of disputing it, if it is allowable, I will say maybe you won't be successful because, you know, landlords want their money, or landlords have an excess amount of expenses or overhead costs that is associated with that. So that's something to consider. If you are month to month, what is the maximum amount? Yes. So month to month is the same. If you are an apartment complex or a duplex, it is going to be the same if you were on a lease. Well, lease, if you're in a lease agreement, it just really means that they might not have a change in rent during that lease period. But month to month, just know that it's 10% right now. I just read the notice of termination. They marked something saying your tenancy, if any, in the premise is terminated 60 days from the service of notice. That's the only box. Yeah, so if that's the only box they put, definitely give us a call. This is something that we would provide education to them to let them know that that might not be a valid termination. Where can we check for the most current and accurate CPI? So your best option is this. It is to go to bls.org, no, bls.gov. You can go on their website and then you can try to navigate it. The easiest way that I have found is on Google. You just type in San Francisco, Oakland, CPI. That's it. And the first link that usually appears is going to be a link that directly sends you to what looks like a map, not a map, a bar graph. But on the right margin is going to be a PDF version. And then you click on the PDF, you're going to scroll. It usually is on the second or third page. There's a table. And on the table, you will see what the 12-month change is. And so you want to use a 12-month change, not a 2-month change, because they're going to provide you two types of categories, a 2-month and a 12-month, and you want to use a 12-month. That's the way I do it because it's quick and easy and I don't have to really navigate the website directly. But in doubt, you can always give us a call and we can totally look that up for you. So something that I do want to mention is that a landlord claiming to be exempt from AB 1482 must provide written notice that they are exempt from AB 1482. And so I provided the language here. I've had discussions with owners about, you've never provided the tenant language that says that you're exempt. So your notice may not be valid until you serve them this specific language. So that's something to keep in mind for you owners on who are participating today. Please be aware that, you should be providing language that says that you are exempt. So someone's asking, they live in a BMR unit, and the last renewal, they increased my rent by 10%. I'm currently in the renewal process and I'm suspecting they would increase again. What is the maximum increase for Emeryville? 10%. So as I mentioned, this 10% is for all of the county, whether you live in Oakland, whether you live in San Leandro, it is 10% across the board in Alameda County. So hopefully that answers your question. So two other legislations that I want to touch right now is SB 329. This basically says that owners cannot discriminate against applicants who have housing choice vouchers. So if you're a Section 8, the landlord cannot say, I'm denying you because you have Section 8. That is a discriminatory practice under fair housing. It was passed in 2019. And so, it's something that we do keep aware of because, landlords do say that from time to time. So that's something to keep in mind. And then AB 1110. And this one's going to be equally important because this one says that if you live in a unit that is exempt from AB 1482, and they do try to increase your rent more than 10%, you are entitled to 90-day notice, okay? So that's just something to keep in mind, that if you live like in a single family residence or a townhouse or a condo, and they say, we're increasing your rent 25%, they have to give you the 90 days. There's no longer 60 days, and I'm going to talk about that in a few slides. But I just want to make that note. There's only 30-day notices and then 90-day notices for rent increase. And then someone says on the chat or in the Q&A box, he just say about AB 1482. My recommendation is for you to reach out to us because I need a little bit more context of what's going on, and I'd rather have a conversation with you over the phone with regards to whether or not your documentation is valid. And then it looks like I have a few questions in the chat. Oh, yes, sorry. This was, so it says, and the letter I get for termination says Tenant Protection Act applicability. So yeah, so we need to review that. Send us an email, call us or something, and let me know. So we can either talk to myself or Tanya about what this means, because I would like to see the document in hand. So we're going to take a minute just to do some Q&A. So please submit your questions in the Q&A box, please. So it looks like we don't have any questions. So I'm going to continue. And the next thing that I want to talk about is issuing rent increases. We've just talked about what are allowable amounts or the percentage that they're allowed to do. And so things that I kind of want to provide you more information is things that you want to look at. So the number one thing is that a valid rent increase needs to be served correctly. And so what this means is that they need to personally serve it to you. They can post it on the door and they have to mail it. So let me make this clear. If they're going to post it on the door, they will also need to mail it. They cannot just post it on the door. And, I've spoken to property managers about this. They're not happy about it, but I tell them, hey, these are the rules. You're a manager. You should know what the rules are. If you don't know what the rules are, we can sit down. We can have a discussion about what these rules are so you can get some education, so you can better know how to serve the tenants that you work with. But this is a posting and mailing. And then they can also mail it to you, okay? If mailed, it's presumed to be served 5 days later. In other words, landlords and property managers should be planning an extra 5 days in your rent increase notice. So if they're going to mail it to you and they mail it May 1st and you received it May 5th, but it's supposed to be effective June 1st, I would call up the landlord and say this is not valid because you need to provide them 35 days and you only provided them 30 days, even though you mailed it on the 1st, because it's supposed to be 5 extra days because you're mailing it. So